Hello, my name is Gabrielle DeMay, and I'm going to be discussing the recent and controversial Supreme Court ruling regarding same-sex marriage. As you probably know, on June 26, 2015, the Supreme Court announced their decision in the case Obergefell v. Hodges. In a 5-4 ruling, the court effectively legalized same-sex marriage by declaring all states' bans on same-sex marriage unconstitutional. This includes Texas's constitutional definition of marriage as between one man and one woman. Throughout Texas and the nation, many religious conservatives dusted off their First Amendment rights to protect themselves. But before we pit gay against God, I would like to address a different question that has been drifting through the minds of lawyers, politicians, and citizens alike. Does the Supreme Court have the authority to do this? At first glance, yes. In the Texas Constitution, Section 1 of the Bill of Rights states Texas is subject only to the U.S. Constitution. The U.S. Constitution, in Article 3, creates the Supreme Court and designates many of its powers. So it seems they were right. Many people would stop there, but I'm not finished. In 1971, in the Supreme Court case Rodriguez v. San Antonio, the question was asked if Texas's funding plan for public education, which, due to property taxes, provided unequal education and educational opportunities, violated the Equal Protection Clause of the 14th Amendment. The Supreme Court held that it wasn't in violation because education isn't a federally protected right. Education isn't federally protected because it isn't mentioned once in the U.S. Constitution. This case is relevant because, like education, marriage isn't mentioned once in the U.S. Constitution. Therefore, marriage is not a federally protected right. One then begins to wonder who can create laws regarding and regulating marriage. U.S. Amendment 10 clears this up, stating, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Since marriage is neither delegated to the federal government or forbidden to the states, it is left to the states to create and regulate it. Some may believe this argument weak because it doesn't address the primary tool the Supreme Court used in the Obergefell ruling, the 14th Amendment. This amendment provides, among other things, for equal protection under the law. But if we turn back to the 1971 Rodriguez v. San Antonio case, the Supreme Court decided the same provision of the same amendment couldn't be applied to education because it wasn't a federally protected right. So going by a previous ruling, logic dictates the Equal Protection Clause of the 14th Amendment cannot apply to marriage because it isn't a federally protected right. Critics of this argument may feel a similar case from nearly 50 years ago insufficient evidence, so we will pretend the 14th Amendment can be applied to this case. Professor Michael Paulson, a leading scholar in constitutional interpretation, maintains equal protection under the law just means equal treatment for all people under the same law. The Texas law that defines marriage is the same for everyone, and it is a reserved power. Paulson argues that the idea at the heart of the Equal Protection Clause is protection from discrimination based solely on an irrelevant personal characteristic, but the Texas marriage law doesn't forbid same-sex marriage based on any characteristic, but on the relevant fact that a man wishes to marry a man or a woman wishes to marry a woman. Also, the law defining marriage as between one man and one woman cannot be discrimination against same-sex marriage because it does not solely exclude same-sex marriage. It also prevents polygamy and, along with other laws, marriage to an animal, an inanimate object, or a child. Anyone for repealing the marriage law in support of the same-sex marriage would be supporting the others, intentionally or not. In the end, Texas and other states with bans on same-sex marriage were right. New York and other states that legalized same-sex marriage without federal interference were also right, and the Supreme Court was wrong. The 4 conservative justices wrote powerful dissents on the case, including their disappointment at the failure of the court to properly perform its duties. Justice Scalia speaks of the decision that should have belonged to the people, and calls the decision unabashedly based not on law, but on the reasoned judgment of a bare majority of this court. Justice Alito writes, "If a bare majority of justices can invent a new right and impose that right on the rest of the country, the only real limit on what future majorities will be able to do is their own sense of what those with political power and cultural influence are willing to tolerate." So one question remains. Will we tolerate this?